So basically, there are two types of evidences. First is oral, second is documentary. Now, electronic forms are part of documentary as well. Now, oral evidence means and includes all statements which are made by witnesses in the court under oath. Now, unlike how you see in the movies and all, none of these witnesses touch their hands on a religious book like the Bhagavad Gita or the Quran. It's just verbally reassuring the court that whatever he states is going to be the truth. Now, in oral evidence, the witness states the facts by either speaking or with gestures. Say, I've been called as a witness and I've been called to identify the accused. Therefore, I may be able to point out that the accused is sitting there. He was the guy at the scene of the crime. I recognize and I identify him. That will be admissible. Now, oral evidence is provided under Section 59 and Section 60 of the Indian Evidence Act. Section 59 of the Evidence Act says that all facts can be proved orally, except, of course, for documentary or electronic evidence. Section 60 states that all oral evidence must be direct. For example, if there's a crime that has been committed and there's a person who was present at the scene of the crime, then whatever he heard, saw, perceived, or whatever his opinion which was formed, all of this is considered as oral evidence and is admissible. Now, usually people living in a civilized society, they're generally very insensitized when it comes to a crime being committed in their presence. The natural reaction is always for a person to run away from the scene. Of course, they'll stand, they'll observe, but once a police authority comes to question you, they will run away. So now what the cops do in the process of the investigation is they figure out which all were the people who were present at that time. So they are being summoned to the police station, and whatever they saw is orally explained to the cop, and the cop reduces that in writing. Now that is under Section 161 of the CRPC, wherein the police officer conducting that investigation is empowered to examine orally or any person supposed to be acquainted with the facts and circumstances of the case and records the statements of these witnesses. Now, the statements of these witnesses are called, we refer to them colloquially as 161 statements. Now, the job to gather all this important evidence against the accused is of the cops. After gathering all this evidence, they file a charge sheet. Now, these statements that are recorded at that point of time will be perused by the court before taking cognizance of the charge sheet. But once trial starts, this statement cannot be admissible. The only purpose of this statement is a substantive piece of evidence, and it can only be used to corroborate the facts or else to bring out contradictions or omissions of the said witness. Now, oral evidence is much less satisfactory proof than of documentary evidence. But justice cannot be administered in the most important cases without resorting to it. We need to have eyewitnesses, especially in terms of criminal investigation. In criminal trials, an independent witness is very important. In all civilized systems of jurisprudence, there is a presumption against perjury. The correct rule is to judge the oral evidence with reference to the conduct of the parties and the presumption and the probabilities legitimately arising in the case. So another test is to see whether the evidence is consistent with common experience of the mankind. Now, to make sure that oral evidence is not misused and does not hamper with the delivery of justice, a few guidelines have been laid down. The oral evidence needs to be consistent with the circumstances, whether it stands true and does not deviate at the time of cross-examination. The witness must always hold his story. During cross-examination also must never deviate from the facts of the case. For example, it's a really silly example, but if the sky, say, if he mentioned in the chief examination, the sky is pink in color, and through cross-examination, the lawyer deviates and gets him to admit that the sky is actually pink in color or blue in color. Therefore, that completely eradicates the testimony of that witness, and it's not considered reliable. In case the oral evidence pertains to a fact that has been seen, then it is the witness who needs to have seen it and cannot give an oral statement based on hearsay. A witness cannot come to stand and say, yeah, my friend Pankaj saw this incident happen, therefore I'm pretty sure the incident has happened. That is considered as hearsay evidence. It's not admissible. If the court finds it so necessary, then proper documents to support oral evidence also are called for usually. Now, when I was talking about the 161 statements, which the cops would record before the trial begins. Now, how to bring about contradictory statements. The contradicting statements are when the witness testifies before the court that a certain fact has existed without stating in earlier testimony given to the cops. Therefore, the conflict between the testimony before the court and the statement made before the police is known as the contradiction. This is where it comes in, where the defense lawyers try and poke holes into the witnesses' statements by discrediting them. So there's a contradictory statement, there's an omission. An omission means exclusion or leaving out. Now, if a certain fact is testified by a witness in his examination in chief, such fact which is testified in court had been omitted at the time of the 161 statement. It can now be shown that this was a furtherance. It was an improvisation of his statement now. Usually it takes years for trials, of course, to commence. Therefore, if he has not mentioned that certain fact back then, how is he suddenly remembering it now? Therefore, when you take into account the entire piece of evidence of any witness which is given orally, what is to be seen is the credibility, whether he stands the test of the credibility. Now, oral evidence is evidence which the person giving has himself seen or heard. It has to be direct in nature. There's also duty on a person who is aware of an offense that has been committed to furnish information regarding the offense committed. Now, breach of this duty is a punishable offense under Section 176 and Section 202 of the Indian Penal Code. Let's come to hearsay evidence. As I mentioned, hearsay evidence is when a person has not particularly seen an incident himself or heard anything, but has actually heard it from the mouth of another person. This kind of evidence is the weakest kind of evidence and is admissible only if it is backed up by another strong evidence which can be proved. Then there comes judicial evidence and non-judicial evidence. Now, judicial evidence is, of course, when a person goes before the court and deposes in front of a judge under oath. That evidence is produced directly in front of the magistrate or a sessions judge. That is known as judicial evidence. Non-judicial evidence is the evidence which is confessed outside the court, not in front of a magistrate. This evidence is only admissible if it could be proved in the court at a later stage in the form of a judicial evidence. We come to dying declaration, which was touched upon by Kushal. Now, dying declaration, when a statement is made by a person as to the cause of his death or as to any circumstances of transaction which resulted into his death, in case in which cause of his death comes in question, is admissible in evidence. Such statement in law is called dying declaration. Basically, wherein he speaks about the incident that had happened, which has caused his death, and thereafter the person dies. That last statement where he narrated the facts of what exactly led to his death, that is known as a dying declaration. Now, you should know dying declaration, once the person dies, obviously he cannot be cross-examined. So the admissibility of a dying declaration is very important. And only a judge rules on whether certain declarations are admissible or not. So a statement by a person who is conscious and knows that death is imminent, considering what he or she believes to be the cause of the circumstances of death, that can be introduced into evidence during a trial in certain cases. A dying declaration is considered credible and trustworthy evidence based upon the general belief that people, as Kushal had mentioned, that people who are about to die will not lie. This is a basic presumption. So as a result, it is an exception to hearsay, because that person who is dead now is not coming before the stand and then narrating it. It is now becomes a hearsay evidence, and this is the exception to it, of when it is admissible in court. If a person who has made the dying declaration had the slightest hope of recovery, no matter how unreasonable, the statement is not admissible into evidence. A person who makes a dying declaration must, however, be competent at the time where he or she makes the statement. And I'm not just talking physically, I'm talking mentally as well. A dying declaration is usually introduced by the prosecution, but it can also be a dying declaration made on the basis of a signature. The court must be satisfied that the deceased was in a fit state of mind to make the statement after the deceased had clear opportunity to observe and identify the persons attacking him, and that he was making the statement without any influence and it was being made voluntarily. Once the court is satisfied that the dying declaration is true and voluntary, it can be sufficient to find the conviction even without further corroboration. Now, when is a dying declaration not admissible? If the cause of death of the deceased is not in question, that is, if the deceased made a statement before his death relating to anything except the cause of his death, that declaration is not admissible. The only thing that is admissible is how he died. If the declarer is not a competent witness, now a dying declaration of a child is inadmissible. Same way, if there are inconsistencies in his dying declaration, it can have no evidentiary value. A dying declaration should be voluntary, cannot be under the influence of anyone. If it is under the influence, it cannot be relied upon, it is not admissible. It is perfectly permissible to reject a part of dying declaration if it is found to be untrue and if it can be separated. A dying declaration must be complete. It is not that he's talking, making some kind of averments and then he dies in between. Whatever he said before then is not at all admissible. He needs to complete his exact declaration and then only does it become admissible. If the statement relates to the death of another person, if whatever the person states does not relate to his death, but to the death of another person, it is not relevant, therefore it's not admissible. Contradictory statements. If the person has made one or more dying declarations, this tends to happen, but between, say, he's made 3 dying declarations. With those 3 dying declarations, in case there is any contradiction that has taken place in any one of them, all 3 of them will be ruled inadmissible. And of course, a person who is of unsound mind, his dying declaration is not admissible. Where, for example, a married woman dying of burns was a person of unsound mind from before itself, and the defense can prove that. And a medical certificate at the time of her death vouched for her physical fitness, but not of a state of mind at that moment. The court will not admit this into evidence. Next comes expert witness, as Kushal had already touched upon. That comes under section 45, makes opinions of specially skilled persons relevant. Now, an expert is defined as a person who, by his training and experience, has acquired the ability to express an opinion. He has, say, a certain kind of degree towards stating it, like a handwriting expert. The purpose of an expert opinion is primarily to assist the court in arriving at a final conclusion. Now, in general, it may be said that there are 2 distinct classes of cases in which expert testimonial is admissible. In one class of cases, the facts are to be stated by the expert and the conclusion is drawn by the court. In another group of cases, the expert states the facts as well as gives his conclusion in the form of an opinion, which may be accepted or rejected by the court. So an expert witness's statement is always corroborative in nature. It cannot be the sole purpose of a conviction. So that is dealing with oral evidence.